So I'm Lauren Regan, and I've been doing a lot of public speaking about the AETA, so it's nice to hear someone else have to give that speech. I'm from Eugene, Oregon. I do a lot of public lands litigation, mostly federal timber sale cases, as well as Endangered Species Act and trying to stop aerial sprays and whatnot. And believe it or not, a couple times we would go seek injunctions from the courts and the judges wouldn't give them. And so logging would start to proceed, and my clients that were mostly nonprofit environmental organizations would go out to the woods, would lock down to gates, would try whatever way possible to stop the logging that we were unable to stop as lawyers. And I quickly learned some criminal defense as a result of that. My clients were being arrested and charged with crimes. There were no lawyers to represent them. They would either have to get public defenders or fundraise large amounts of money to retain lawyers who were somewhat intolerant of the political aspects of their cases. And so I learned criminal defense and started representing protesters and activists. And then we had a few instances where activists were beaten by law enforcement. And so I quickly learned some 1983 civil rights litigation and started doing police misconduct litigation as well. And about 5 years ago, started the Civil Liberties Defense Center as basically the legal tool in the toolbox for the progressive social change movement, which definitely included the animal and environmental movements, particularly, especially where I'm located, which is sort of a hotbed of environmental and animal rights activism. Most recently, I was one of the lawyers that represented 4 of the non-cooperating Green Scare defendants. Those that were charged in Oregon with committing acts of economic sabotage, as Will discussed. I won't go into a lot of detail, but I'm happy to answer any questions afterward about that. And now most recently, I'm one of the lead attorneys working to constitutionally challenge the Animal Enterprise Terrorism Act. As Will alluded, this is a grossly unconstitutional law, and its impact is extremely chilling on even lawful activism in the animal rights movement. I think based on it having been passed in November of '06, we've had it for a little over a year now, that it could be one of the largest threats to the animal rights movement. We hear regularly that people are afraid to go to lawful protests, are even afraid to be associated with certain animal rights groups because of this label of terrorist. And under the AETA, because of the Patriot Act, there is an expanded warrantless wiretapping provision and an expanded spy provision that if you have any association with a target of an investigation, you are lawfully allowed to be spied upon as well. And so like Will was saying, it's not just the radical left that is being targeted. They are using this law as a shoehorn to be able to get into even the most lawful mainstream organizations. And in my opinion, the reason comes down to corporate profits. These laws were passed by an entity called ALEC, the American Legislative Exchange Council. It is a think tank of multinational corporations that were losing money. Like Will mentioned with the Shack case, getting HLS taken off the stock exchange, having a very concerted, effective campaign against vivisection and rodeos and circuses were hurting corporations in the pocketbook. And they were able to buy legislators and buy legislation in order to hinder these efforts. And so in addition to filing a lawsuit this summer challenging not only the usual constitutional issues that we lawyers know about, but we're also bringing back some 1960s case law from the NAACP talking about laws that specifically chill First Amendment rights. And it's our opinion that just the name of this law, you know, it used to be called the Animal Enterprise Protection Act, but after 9/11, Congress decided that it was a little dicier to call it the Animal Enterprise Terrorism Act. And especially for a movement that's never harmed a living thing, that seemed a little bit over the top and in and of itself chills First Amendment rights. And so we're going to be bringing back some of the NAACP v. Button case law for you law students and see what ground we can cover with that. We also started a national grassroots coalition bringing together animal rights, environmental, labor, who is also targeted by this law. If a labor organization boycotts a university for labor reasons, but it also is doing vivisection, and that vivisection entity loses profits, the hindering of profits, which is a component of the law, they can be targeted as terrorists as well. And so we've brought together labor, environmental, animal rights, religion. We're trying to bring as broad a group of people together, and not because of necessarily wanting to save bunnies and kittens, but because the bastardization of the English language by calling things terrorists that are not terrorists is harmful to us all. And I've actually been quoted a lot of times for this, so maybe people have heard it, but I mean, there is truth to the saying, if everyone is a terrorist, no one is. And the labeling of radical activists as terrorists make us all less safe because there's no distinction between people who kill humans with airplanes versus people who burn horse slaughter facilities with no threat to human life at all. I'll also mention that some of the large animal rights coalition or some of the large animal rights groups have refused to take any action on the AETA, thinking that it's an issue that is not of concern to them. It hasn't risen to the level of being a problem for them, apparently, and I would say that when membership and funding starts to decline because of this type of law, I think it will become an issue that we all should be paying attention to. I also wanted to mention that Seattle is a particular hotbed for these issues. Every 6 blocks in Seattle is an animal laboratory, an animal research laboratory. And so this is an area where lawyers helping activists is incredibly important. And so with that, I wanted to talk about some nuts and bolts of representing activists. First off, I wanted to talk about communication. Lawyers get bar bitched for lack of communication more than any other reason, according to bar polls. And it's a two-way street getting along with your lawyers. We always tell activists, don't automatically assume that just because your lawyer isn't an activist, that she's not equipped to represent you. Because whether you're an activist or you're a mainstream corporate lawyer, there are skills that both sets have that are extremely useful. When we go into courts that are not our normal courts, the judges don't know me, but if I go in with some old school guy who's in there every day, a public defender from that area, they know the prosecutors, they know the judges, it gives me credibility in being able to go in there with those people. So whether you are, one of what we will call more mainstream versus, a lefty activist lawyer, we need both, and in order to be successful, we want to build those coalitions and that solidarity. Also, a lot of criminal law turns on knowing what motions and defenses work in a given court, and without having somebody to translate the customs and practices of a particular court, you won't be successful in that court. And so having that local flavor is essential. Depending on the charges, like the felony federal terrorist charges that my clients were working on, you need extremely experienced criminal defense lawyers in those circumstances. There are some cases, like regular locking down to a gate, low-level misdemeanor protest cases, that any lawyer could handle them, especially when I do massive group representation of protesters. It's a great time to bring in people who only do environmental law or only do family law. So many times I'll meet lawyers that say, I do wills and trusts, but I'd love to do what you do. And so when we get a large protest, I call them up and I say, come try it out. You can shadow me. We'll be filing all the same motions. We'll have the same facts. We'll be representing different people. You can try it out in the safety of having some support. And once they do one or two of them, they're competent to do them on their own, and we've just doubled our efforts to represent activists. The next thing is you got to be tactful, make yourself likable. The clients need to also understand this, and they need to make you want to work hard for them. Especially if a lot of us are doing this work pro bono. Don't forget that just because you're working for free doesn't mean that your representation of this person is any different than if the person just dropped a $50,000 retainer in your lap. You have to zealously represent them as if they were paying your full fee. And don't be surprised when activist clients are a little bit more inquisitive and want to be a lot more involved in their case than maybe some of your other clients. And take advantage of this and enjoy it. The associate in my law firm started off as one of my clients. She got arrested protesting the circus. We won her criminal case. We sued the cops for illegally arresting her and violating her First Amendment rights. The money we won, she went to law school. She clerked for 3 years. Now she works for my firm. So you never know when those inquisitive clients can end up joining you in the fight for whatever you strongly believe in. Don't forget to listen to your client. Just because your client comes in and is paranoid doesn't mean that they're really not out to get her. Especially in this day and age, they could very well be truth to those. And there is such a thing as a political case, and activists are targeted simply for their activism. Don't forget to, no matter what the movement is, learn something about your client's movement and its history of repression, and learn something about what it is that they were fighting for. Whether it's vivisection or hunt sabotage or whatever it may be. In some ways this is a painful situation. With the Green Scare cases, I had to watch video about horse slaughter. And it's a picture that will never leave my brain now. And before that, we had a case dealing with pet theft. And to this day, my partner thinks I'm weird for locking the dog in the car, even if I'm just running in to buy, something in the store. But there are parts of it that, will affect you for the rest of your life. But that's also why that person risked their liberty in fighting for that reason. And it's important for you to remember that they're not just kooks or young kids or people with more time than we have. They're people who have actually taken a great risk of their personal liberty for a cause that they strongly believe in. So you got to be resilient. Political clients demand and deserve to be represented as political people. And even if your client comes off a little distrustful or resentful, work for that client's trust and respect rather than being resentful in return. Don't forget there's usually some history there, and often it's poor representation in the past by maybe a well-meaning lawyer or a public defender with a dump truck behind him that may have given them that bad feeling. And I always joke that it's sort of the same principle as fostering an abused animal. Don't forget that people have history behind them. With pro bono lawyers, please don't cop the attitude that you're doing the client a favor, so the client should be grateful. There is no exception in the ethical rules for some differentiation between pro bono versus regular representation. Don't just deal your client out because you're not getting paid or you're not getting paid very much. Your client may want a trial. We call these show trials sometimes. And like Joyce mentioned, sometimes you go into it knowing legally you are not going to win this case. But if your client wants to go to trial, wants their day in court, wants the jury to hear their situation, number one, you may just get a jury nullification type of verdict, which I've had happen a couple times, where the jury just decided that they liked my client too much to convict them. They are smart enough to understand that that conviction may very well be the case, and will take it. They've probably, many of my clients have gone to jail before and they're willing to do it again. Discuss expectations with one another early on. Be clear about the scope of your representation, and don't pick it up if you aren't able to deliver. If you're not willing to go to trial or you don't have trial skills yet, don't take the case. Or if you do, make sure you've got a mentor or another lawyer that's willing to come and second seat with you. I mean, it's a great, some of these misdemeanor activist cases are great learning experiences for law students and lawyers alike. If you run into problems with a client that you just decide you can't work with them, or they've done something that makes you think that ethically you may have a problem in continuing the representation, you are entitled, obviously, with limited exceptions, to withdraw, and the client also is entitled to the counsel of their choice. So sometimes things happen where you're going to be parting your ways. Discuss this internally. Don't inform the court or the prosecutor of it. Swallow your ego. Assist the person to find a substitute. Try as best you can behind the scenes to get that person another lawyer, and then just do a quiet, simple substitution of counsel if at all possible. Obviously, prosecutors will take advantage if they think that there is something going on behind the scenes, and you don't want to prejudice your client's case. The next topic is solidarity versus conflicts of interest. You need to represent political clients politically, and you need to, right from the get-go, discuss conflict of interest disclosures and waivers and the pros and cons of that. This has to do with joint litigation groups, joint litigation defense. It happens on both the civil and the criminal side. It could be a group of protesters that want to be represented as a group, or it can also be a group of nonprofit organizations that are going to go sue over something. In your materials, I included our version of the joint representation agreement and conflict waiver. We make all of our clients sign this. In essence, it basically says, we've been told what conflicts of interest are, and we lay out what a conflict of interest is. And we agree that our interests are united, and we want to be represented as a group. This is much more common in political cases than probably any other area of the law. And it can be extremely effective. With the Green Scare cases, we had one of these joint defense groups, and here's a couple of the highlights of how it helped. Number one, a couple of the clients had court-appointed lawyers that weren't necessarily up to par in taking on these cases. Because we had a group of lawyers, a brain trust, we were able to float those with lesser representation and make sure that they had the best representation possible because of that group representation. Second, we were able to facilitate some solidarity amongst these people. They wanted it. That's how they wanted to be represented. And because we all had attorney-client confidences as a group, we were able to allow that communication to take place. And obviously, 4 brains are better than 1 in some instances. We were able to divide up the work, and for the first time in a criminal case in my experience, we papered the prosecution to death. We filed motion after motion, made them work their asses off, and ultimately won on a bunch of stuff that they just didn't see coming. And so being able to divide up the work, everybody had a little bit of a different area of expertise that they were familiar with, and it made for a much stronger legal defense, and in my opinion is the reason that we were able to secure non-cooperation agreements for our clients when the feds for years had told us snitch or go to trial, and those were our only choices. So it had a great effect there in having some bargaining power for us. You have to recognize that with political movements, snitching is not a good thing. And in the federal system especially, there is a snitch culture that is perpetuated. In our case, there was no investigation or law enforcement success that brought the case to trial. It was informants. It was the government coercing, pressuring, entrapping people and getting them to roll. And so with movements throughout history, it is up to lawyers to play a part in this role. It's not the job of a lawyer to just walk their client into the FBI and say, okay, inform on everybody you know, destroy the movement you once loved, and then go off and never have the same life again. But when you are sitting across from a client in the heat of an actual case, that's not the time that lawyers can be advising to snitch or not. That type of education has to come beforehand, and for progressive lawyers, it's a public education role that we should serve long before the fire hits the kitchen, so to speak. Because once you've got that client, your duty is to the client, and at that point we have to say, you have two choices, inform or not inform, and here's the consequences of that. And they're looking to you as this lawyer to help them, wondering why you've just told them that they have the option of becoming an informant. You have to explain to them that we have these ethical duties and we have to advise you of all your rights, and these are your choices. And it's up to you to already know where you stand on those issues before you walk into the lawyer's office. But again, you can equally present both sides of the issue, and you can satisfy your ethical duty of zealous representation and undivided loyalty if you are catering to your individual client's desire to maintain cohesion and solidarity among co-defendants and their community in general. That is ethically correct. You may also be given instructions from your client to work cooperatively with co-counsel, to work cooperatively with some legal liaison that is going back to the community with information. And recognize and respond to community interest and defense support committees. Liaisons are a great way to have somebody who can span between the two worlds without you having to constantly be deflecting phone calls about that. And don't be too quick to shy away from the politics of the case. Every case is different, but some are just asking to be political cases. Be receptive to political style defenses, like choice of evils defenses or necessity defenses, jury nullification type defenses. And don't necessarily shy away from the media, especially if your client is asking for that. There's obviously certain ethical rules, like right before trial and stuff like that, but there are ways for lawyers to play active parts in making sure that even if your client's going to get convicted, that those larger issues are going to get out to the world. Safeguard the welfare of the community which your client is a member of. Don't enable the government to widen the net of counterintelligence and harassment. Remember privacy and confidentiality of third parties, and vigorously assert privileges like First Amendment interests in preventing government harassment of fellow activists and community members. And the National Lawyers Guild successfully asserted a First Amendment privilege on behalf of legal observers after a big demonstration. So the issues go wide. If you need to, seek protective orders or get on the phone and find other lawyers to represent third interest parties. If you can't do it, find somebody else to come in and assert the interests of an organization or an individual whose name is being brought up in court and might have an interest in that. Communicating between co-counsel, secure email lists, if there is such a thing anymore. Using PGP and other things like that are a way for lawyers to be able to communicate with each other in a confidential way. Obviously, there's been recent cases where the government now has admitted that lawyers are being spied on just like anyone else, including attorney-client privileged information. It's going through the court system, but don't assume that your emails or phone calls are privileged or are not being listened to just because you've got a bar number. Meet from time to time in person with your lawyers and clients. This is a great way to make sure everybody is in cohesion with each other, and it's kind of an empowering experience. It's sort of like your rah-rah. You remember why you worked all weekend last weekend when you're sitting with this group of people that did the same thing. Let's see. Privilege and security issues. especially if you're in joint representation, you need to remember that anything that happens within your joint representation is considered attorney-client privilege. If for any reason someone leaves that organization or leaves your group, this agreement protects you from being able to stop that person from disclosing privileged information. This happened in our case where one of our members decided to become an informant. We were able to make it so that that person, when he went to do his federal debriefs with the FBI, was unable to answer any questions that came up during our joint representation and our legal team. So it's a way to protect information, and it works the same in civil cases as well. Don't just assume that it exists. So many lawyers in the old school way would do these things verbally, where you'd sit around the table and everybody'd say, yeah, you know, blood oath, we swear, we won't tell. But the only way that you can really enforce it in court is to have it in writing and signed by everyone. So make sure everybody knows what it is, make sure everyone signs it, and follow it. You know, make sure that you enforce those agreements and assert those privileges unflinchingly. Exceptions to rules in activist cases. Probably one of the biggest exceptions are allowing your client to court the media and make statements about their case. And you know, normally, especially in criminal defense, you say nothing, you know, and because you're going to go to trial and they'll use anything you say against you. Well, in political cases, especially in cases where there is no doubt, because it's on the Channel 5 news, that your client locked down to a gate that they were not allowed to lock down to in order to stop a timber sale, there's not really going to be a lot of harm in them going on the local news and talking about how they locked down to the gate and why they did so. And so in those circumstances, even though it kind of makes lawyers wince, you have to understand that that's probably okay, it's not going to harm their interests, and in fact, is to the benefit of them and their movement, particularly because the wheels of justice grind ever slower, and by the time your client gets into court for a trial, it could be a year or a season past when the action was. So if the point of a bunch of people locking down to something was to draw attention to something that was happening right now, telling them that they can't go to the media until after their trial is like telling them to cut off both their arms and legs. It's just, you know, a senseless exercise for them. So you don't necessarily have to do any media with them, though there certainly is an important role for lawyers who are willing to do that. And like I said, consult your local ethical rules about, you know, the different bounds that may exist for that. But, you know, these cases are fun. For the most part, they are not necessarily difficult until you get up into green scare level stuff, and then they're extremely challenging. And it's a great way to contribute to a movement you support. You know, if you're vegan, if you care about animals, if you care about the environment, taking a pro bono case to defend some of these people is a great asset that you can provide, because you know, many of us were activists before even going to law school, and that bar license gives us a tool that a lot of other people don't have. And so if you can use what you have to benefit the movement that you're a part of or you have solidarity with, it's a really rewarding experience.